Yeah. But let's talk about what we're doing in our practicum, and I'm going to turn it over to Bernadette to talk more about what's going to be going on in our actual world.
Thanks. So before actually I do Pro Se, I should just give a shout out to Monica Wallace, who isn't here today, but was one of Judge Arcara's long-term law clerks, and she's running the re-entry practicum and doing a great job with that. I've taken over the Pro Se civil litigation practicum, and what is interesting about this practicum and challenging in some ways is that we are combining both federal court practice and family court practice. So as Bob Alardo might tell you more about, we actually have a sister component over in the family court that Bob, an attorney at VLP, Natalie Stutz, and also Gail Murphy have been critical in getting up and running, and it's been running for a whole semester now. So we know this program can be successful, and we are going to combine both those programs, at least for purposes of education, under this rubric of Pro Se civil litigation practicum. Now, I do have my co-instructor and the person who's helping me develop all of the curriculum and the classwork, Bridget O'Connell, who's here. And many of you will know her. She's been a long time practitioner in the area of family law, a mediator in family law, and is now, of course, over at the family court. So Bridget's going to come in and really bring that depth of experience in terms of the family law to our students. I feel that I can bring the federal side of things, clerking for Judge Cretney and having practiced here as well, and been appointed counsel in cases. So I will bring the federal law side of our practicum to the students. Now, we will have a classroom component which will meet once a week for 3 hours. And as part of that classroom component, we're going to make it very interactive. Practica have to tend to be small because we have to be able to have contact with all the students. We have to be able to have work for those students as well. And I think as Chief Judge Cretney noted, we are going to hopefully be able to really increase the pool of litigants who come through the doors. In family court is pretty well up and running, but in federal court we'd like to see the same thing happening. So 3 hours a week of instruction, and in class we are also going to bring in some practitioners, support staff, both Chuck Kara, Betsy Sterling from the Pro Se Attorney's Office in Rochester and Buffalo will be coming into the classroom. We'll have Bob Villardo coming to the classroom. We'll have other attorneys from VLP coming to the classroom. So it's going to be a really dynamic environment. We'll have a set curriculum, but we'll actually be bringing the practicing attorneys in. And that's near and dear to my heart because I teach advanced legal skills and have been both a practitioner and a professor. So it's something that I really believe in doing to get the students up and profession ready, as Kim says. Of course, Kim's got some other things that we do here, the work for the students, but in addition to counseling pro se litigants when they come in, especially till this program is up and running, the students will also be taking a very active role in looking at particular legal issues that both VLP needs in family court and the pro se attorney's office here in the Western District, both in Rochester and Buffalo, need. So they will be not just sitting at desks if no one's there not doing anything, but actually researching and writing and working with this broad spectrum of attorneys to get information out to the public. Also to the volunteer lawyers if they should need it, if they need a particular information on a certain practice area that perhaps they don't do all of the time. So the students are really going to have an active role with that, and we'd like to expand it. This is our inaugural year. So anytime that you have a class that you're developing, you have to see what's working and what's not. But eventually we would like to look into Rochester and getting a program going there. We'd like to look into community education. Oftentimes these are called people's law schools. So where presentations are put on by the students. And in addition, in the classroom, not only will we work on the legal skills like research and writing, but our students will also present. So they'll be working on their particular academic paper, and that's going to be fantastic, but it is going to have a practical bent. And those students will then present that paper so they get the experience of getting up and speaking in front of a group. So we're very, very excited about how the classroom component will work. Yeah, and they're maybe just learning this now. So, but they will. My former students actually who take my transactional class have to do this every semester, and it's just a great experience for students to have to present a legal subject in a short period of time in a coherent manner, which you know, even if you don't litigate, happens when you present to your practice group, right? Or at a CLE, or to a client. So these are all skills that we feel can make the law school a richer experience.
We are so delighted that that Bernadette is taking this on in addition to her amazing work with the Legal Analysis Rating and Research Program. So, so one thing that just to note is we do have the new 50-hour pro bono requirement that is required to happen before admission, and both the clinics and the practica are designed to meet these requirements, and so far that's worked out for all the practica so far. That's when you have 120 hours of field work, you're going to do more than 50 hours. So. Now, I was asked just to say something briefly about talking about why again, and the Chief Judge is a lot, so I don't want to spend a lot of time. But we've got a lot of people who are trying to make their way alone. And this is a very tongue-in-cheek cartoon. I have a constitutional right to represent myself, I have a constitutional duty to advise, that exercising that right makes you an idiot. You know, the reality is that there's a lot of people who simply are not just low income, but low level, middle income people who have reasons to be in court and cannot afford an attorney. And the reality doesn't make them bad people, and in fact it doesn't make them an idiot. It makes them not in a place that we can provide them help that we should otherwise be providing. But as we've heard today, this kind of has a reverse impact of the judges and the court personnel spending tens of thousands of hours trying to assist. And so this is what we're trying to do, is to figure out a functional way of kind of helping the people who really need the help. Most of whom would love to be able to afford an attorney and simply can't, are not in a position to do that, but have something valid and have reasons to be there. You know, you hear the stories of the crazy people who are trying to do pro se. There's so few of those. There's just a lot of people who end up in a position of not being able to afford. And I'm just going to tell you a very personal story, which is at the very end of my 3-year custody battle, when I had emptied my retirement and done everything within my power, I had to finish up the representation pro se because I ran out of money to pay an attorney. And you know, so I'm kind of an ideal pro se person because I kind of am a law professor. But on the other hand, you know, it's not just low income people. I mean, people end up having to go pro se for lots of reasons, and it's not necessarily, you know, something that we should look down on, and we need to figure out how to give them the dignity in what they need to go forward. So this is kind of the reality of what's going to happen in the courtroom. And let's just do a couple things. What do students need from those of you who are going to be helping them? You need to hold them to high standards. We hold them to high standards in law school, and you need to continue that. You're going to be lawyering. You need to demonstrate really good lawyering for them because they're going to be watching you. And let me just tell you something really important. Even though I'm actually licensed to practice, I actively practice. I am in the clinical program. They don't think I'm a lawyer. They think I'm a professor. They think you guys are way smarter than me, and in fact, they're right on some levels. So they're going to be watching you much more than they're going to be watching the people who are teaching them in the classroom. And you are going to be teaching them as much, if not more, than the classroom component. Include them as much as you can in the process. I talked about the side-along car. Keep them close and help them really see what's going on. Stay in touch with the law school, volunteer lawyer project. Let us help whenever you can. And supervise gently. These people have their work. this was an application process, not everyone who wanted to be in this practicum got in, but they're still novices. So supervise them, high standards, but be gentle and understand that they're really new at this. And this is one of my favorite law school things. It's like, you know, I remember being in law school and thinking that law school was really hard. And then you get out in the real world and you're like, I wish I was back in law school because that really wasn't that hard. But for them, go back to your time of being a law student and it felt really hard to them. So be gentle with them on that. So I don't know, I think because we got a late start, I probably need to turn it over. But is there any quick questions for me, or you can find me after? I'm really easy to find. Director of Clinics, do a search, send me an email. Okay? All right, I'm going to turn it over to Shakti's our moderator. Are we done with the, are you done PowerPoint?
I have something else.
Here's something else.
Yeah, but not
As we said, nothing happens without Lisa. I have her email address, although she doesn't work. Kim, Bernadette, thanks. Like I said when we started, Kim was really the first person that Betsy and I met with to get this program up and running. The dean and the chief judge met, which meant, okay, someone's got to do it now. And without Kim and Bernadette and others, we wouldn't be here today. So our next presenter is Bob Alaro. Bob is obviously the managing attorney and CEO of the Erie County Bar Association's Volunteer Lawyers Project. And when we started discussing the practica and how we could get attorneys involved in the program, we obviously, the first person we thought of was Bob Alaro. And Bob's going to speak about how the attorneys are going to be involved in this process through a limited scope representation and what that entails. Bob Alaro.
Thank you, Chuck. Yeah, PLP is really glad to be a part of this. Diane Bennett, who was in the audience, was on the very first, it wasn't a board of directors, that was called an advisory committee when VLP was created 31 years ago. And she told me that her real interest, her real interest was in pro se, how to help pro se people. And so finally, all these years later, we're involved in helping, and Diane is here to be a part of it. So, so thank you, Diane. And you know, of those 31 years that VLP's been the Bar Association's organized pro bono program to work with lawyers in the community, I've been here 30 years of those. And what's kept me here is seeing our clients getting help with real life problems, and seeing lawyers in the community who are giving of themselves to help those clients. And many of the lawyers over the years, countless lawyers over the years, have told me that their pro bono work has been perhaps not the most, some of the most rewarding work they've done as lawyers. And so that makes me feel good. That really makes me want to keep working at this, and I hope that you all find that kind of experience with your work in this clinic. Now, the up on the board, you may not be able to see it. There were some materials handed out. I don't think 6.1 was in there, but I just want to
bigger that? Or at least in a bigger that?
But 6.1, I just wanted to start with. You know, in the current rules of professional conduct, the 6.1 is the pro bono rule, and every lawyer is strongly encouraged to provide at least 50 hours of pro bono legal services each year to low-income people and to contribute financially to organizations that assist those people. And the mission for the Volunteer Lawyers Project it's a dual mission, not only to provide quality civil legal services for low-income people, but also to effectively involve volunteers in delivery of those services. And we have a wide variety of opportunities We have 11 attorneys on staff, which is really different than when Diane was at the advisory committee, when we had one lawyer on staff. And 4 of those lawyers are immigration lawyers. So, sometimes you might get people coming in who really don't belong in federal court at all for a lot of reasons. But if it's immigration, we're going to have a system where you can just get them to our immigration lawyers to help. Most of the other things that VLP is involved with, frankly, are the state courts. And this is new territory for us, and we're really glad to be involved. Now, Judge Scretany talked about Judge Lippman and how aggressive he's been in trying to work to get access to justice for low-income people in New York and additional funding. And New York has also, under his leadership, been aggressive in giving lawyers CLE credit for their pro bono work. And now lawyers can get up to 10 of their 24 required CLE credits every 2 years through doing pro bono work. And this work in this program will count. And the way it works is for every 2 hours of pro bono work that you do through a program that, like VLP is separately certified by the CLE board in New York to provide CLE credits for pro bono work. It's a total separate accreditation. So every 2 hours of work that you do pro bono through VLP, you can get 1 CLE credit. And you can count up to 10 of them every 2 years. You can also carry over under the normal rules, which allow you to carry 6 credits over. They can all be pro bono credits if you want. And there's, for those attorneys who are a little bit older, the Attorney Emeritus program is a way that you can sign up on the court website. And if you're signed up as Attorney Emeritus, you can actually count 15 of your CLE credits through pro bono work. The next thing that I really want to talk to you about is also one of the rules, and that's not what we want. Okay, 6.5 is a very important rule for this program. And the rules of professional conduct include this rule, and they were in the old Lawyers Code of Professional Responsibility for the last few years of its existence too. And because I know that as you start to think about this, you're going to be wondering about conflicts. And 6.5, the ABA created many years ago to help these outreach programs to survive, because there's no time for you to check, especially if you're at a large firm, there's no time to check whether you have a conflict with every client you're going to see. And so basically, I'm going to go through it in more detail, but basically, the normal rules about conflicts don't apply. The confidentiality rules do. But the conflict rules don't apply unless you're actually aware of the conflict when you're meeting with the client. So the very first paragraph, a lawyer under the auspices of a program sponsored by a court, government agency, bar association, or not-for-profit legal services organization, that's us, provides short-term legal services to a client without the expectation by either the lawyer or the client, and I'll come back to that the lawyer will provide continuing representation in the matter, shall comply with rules 1.7, 1.8, 1.9. We'll go through those in a second. Those are the conflict rules. Only if the lawyer has actual knowledge at the time of commencement of the representation that the representation of the client involves a conflict of interest. And it goes on to say that also Rule 1.10 only applies if you have actual knowledge. 1.10 is the conflicts rule where those of you in law firms have to worry about whether your partners, other people in the law firm, have a conflict. 1.7 is the regular representational conflict rule. And so that doesn't apply unless you have actual knowledge. Now, 1.8 is financial conflicts and sexual relations conflicts. And then 1.9 is about duties to former clients. You know, not worrying about conflicts if you're in the same or substantially related matter that you represented someone before. And so what Section A is all about, and B actually reinforces A, is that unless you have actual knowledge that the person sitting there across the table from you is someone that you or your law firm has a conflict with, the conflict rules don't apply. The exception is if you find out during the course of talking to that person that you have a conflict, or if the judge decides somehow. I don't see how that's going to come into play here. This rule also comes into play with programs like our Attorney of the Morning program, where the lawyers are actually appearing in court. And if the judge there, just for whatever reason, decided that there was a conflict, then there is a conflict, and that actually happened recently with our Attorney of the Morning program. So the thing that makes this work is that the client has to, along with you, you all know that you're not going to be representing this client further, but the client has to know. And the client has to give written, informed consent. And that's something that we will be working with the law students to have them sign right up front. So that, the statewide, it's a very short statement that's required, that's really to the point, just so that they're signing, saying that they understand that you're only helping them right there at court. It doesn't go beyond it. Okay. So that's really important. If anybody has any questions about that, yes?
Yeah, Bob. So the short-term limited legal services, I don't know if that's how it's quite iterated. In short-term, they acknowledge that informed consent. Are they now my former client in connection with that matter?
Yeah, that's my question. So the conflict is different than disqualification.
You know what I mean? Because, so for example, I'm here helping, and I'm like, yeah, you've got a terrific Title VII claim. Yeah, very much so, and let me help you frame that. And I go back and Tom Bridges represents XYZ Inc. I mean, that's beyond your concern,
I understand. That's a really good question. And in my reading of this, and there's nothing in the comments that talks about it, it says, I think that we have to take the language at its face, that the rules don't apply unless you have actual knowledge with regard to this client.
Well,
so when you go back
yeah.
and your office is representing a claim against that person, if you remember who that person is and you're the lawyer, I think that is a conflict because you now remember that person. If your actual knowledge doesn't get to the people representing, then in my view of reading this,
Well, it would be imputed though, wouldn't it?
Pardon?
It would be imputed, wouldn't it? And I guess my question is, could the informed consent also have a waiver? I think that's a waivable conflict.
Right, so they don't just try to disqualify.
Right, and to say, and I further acknowledge that, I don't know what the standard language is, but that would, I would hate for, again, for Tom Bridges to get a complaint. I'd be like, oh yeah, I helped draft that,
There is language. They have to consent to some sort of screen ahead of time, so I'd be conflicted out, or you would, but I don't want to disqualify my firm or my partners by representing or hearing that person's complaint.
I don't think the conflict would apply. You still have confidentiality obligations. You can't go and let me say, let me tell you. But I think that there's nothing in the comments and there's nothing in anything that's interpreted this to lead us to believe that it would be.
But I think the point is that the consent isn't specific enough. You may have a disqualification issue. Must be imputation because of what's
Well,
imputed.
if you're right, if it comes to light, then you could be disqualified. And so, yes, if it comes to light. If the client comes forward and says, that guy was at the law firm and he gave me advice, I think that the firm could be disqualified.
But that's why I think the consent has to be specific enough to waive that ahead of time, otherwise we're all gonna have big concerns.
Yes, Kevin?
Do you think the issue is advice or the issue is confidential information? And doesn't that counsel toward when you're manning the desk and giving folks advice to be somewhat circumspect about the exact level of information you get them about, from them? Because I could definitely see that, a conflict on the basis of confidential information could be a problem. I think that probably the rule envisions a situation where if you don't have confidential information, that there's not going to be invitation in the way there might be in other circumstances.
I did that, Kevin, but then I go back and guard myself about what I'm going to be saying, what I'm going to be doing, and give it half-assed.
It's a challenge for all of us, Sheldon.
Yeah.
I'm sure that with a lot
But
of
these are attorney-client relationships that are getting formed in that
Yeah.
2-hour window, right?
That's true.
I mean, and so if I'm counseling this guy on how to put a complaint together, and I'm gonna say to him, no, I would not mention that particular fact. That is something, I don't think it's material here. I mean, you're gonna get confidential information.
Yeah, and that may be a situation where you've got a problem.
But, and that's why I say if the standard form that they sign could include, because I think that's a waivable conflict nonetheless. And if they had a waiver and saying, and in the event a counseling attorney, has a firm that represents a party, adverse to me in this matter, I hereby do consent, that such firm, provided it's not the attorney who gave me the advice, shall be able to carry forward the representation.
Well, we'll look at that issue about the effectiveness of a waiver that way, that's prospective. But Kevin is right about confidentiality. 1.6 in subsection D, 1.6, which is about protecting confidential information, definitely does apply. So you need to still keep everything confidential, just like you would for any other client. So we will commit to looking at the waiver issue and see whether that can be put in.
Because I think what you're getting at is if the client consents to probably a screen in advance, and that probably wouldn't be a terribly difficult thing to add, but you have to explain what it means. And so where and I think that's probably, even in a confidential information situation, that screen, as long as folks stick to it, is probably okay.
Well, I think the screen is both intent and work intent doesn't apply when it doesn't matter. In other words, if Sheldon's got a desk, one of his partners is representing in the matter, and he has confidential information, he has a duty to keep to himself. But if the rule 1.10 does not apply because of the limited representation, then the attribution doesn't matter, therefore there's no need for a screen.
1.10 doesn't apply unless there's actual knowledge. Yeah.
And, how could you possibly? And if you didn't have knowledge, you'd say, I got a pass.
Right.
So I'm not so sure you need a screen because of the 1.10 inapplicability under the limited representation, but you can see why people would worry about it.
We'll have an analysis done before the semester commences.
Thanks, Bob.
So what I mean?
I do, I do
Yeah.
understand.
Okay, thanks, Kim. Yeah, we've actually been looking to see if any opinions came out interpreting this, any additional comments, and there haven't been.
Right, we had a student look into this a great deal for the clinic because there are professors, just because of what we do for our handbook. And we couldn't find anything on this a year and a half ago, but we were looking at it in a slightly different context. We will resurrect that research and add to it.
Okay,
And
great.
produce a new memo.
And Bob, have you had any issues with this rule running it through family court or attorney of the day? Has that ever been an issue for you?
There have been a couple of times when the lawyer said, I have a conflict, I remember this person. And if that happens, then we don't want you to talk to them. We will, some of the times, Bernadette actually will be available to advise the person. Otherwise, the law students will have information about other ways we can try to get that person to talk to someone.
We'll schedule them to come in at another appointment to deal with another attorney if that happens.
That was my next question on scheduling. So this isn't just an open 2-hour session where
It's
people
two.
go out on the street.
There's two ways.
There's two ways.
They're going to be able to make an appointment to come in during this 2-hour time block.
In which case you could give us advance notice of the potential party for us.
But then if you
No,
start
we won't.
looking,
Yeah,
that's a bad idea.
And then
Yeah.
you know,
Then you're not, then rule 6.5
Then
is
you
going to
know.
apply.
Yeah, right.
and then there's going to be walk-ins.
Yeah.
There are going to be walk-ins.
Yeah.
Okay.
And we just don't know, I mean, we have no idea until we run this for a while how it's actually
Of
going
course.
to shake out.
Thanks.
Yeah, and in family court, we started in September, and it's been growing there, and that's a very, very busy court. They're overwhelmed with petitions being filed, and we've been averaging about 4 people coming in the 2-hour blocks. Hard to know how it's going to be here, so there's a good amount of time for you to work on that. So I wanted just to talk about also how the program works from the lawyer's point of view. First, in terms of what is it, it's free legal services, and that could be information about how the process works. It could be advice and consultation about specific aspects, very focused aspects of their case, about preparing a complaint. It could be about responding to discovery demands. And I think Chuck and Betsy are going to talk about those issues in more detail. And it could be referring the people to the appropriate place where they can get help. And we'll have information there that the law students will know, about to help you get the person to the right place. Some people who come there maybe don't belong in federal court at all. And so there'll be information about getting them to the right place. Now, there's going to be a handout for the people. This is in your handout materials. And right in the middle it says, the volunteer attorney will not appear in court, research, write, or file court documents for you. Although, as the folks from the law school mentioned, the law students can do research for you guys. And they're going to have internet access right there in the office where you're working. The volunteer attorney will not investigate the facts of the case and will not negotiate. So further, hitting home to them the limited scope of what you're doing. And also, it's going to tell them that you can decline to assist them if you've already given advice to the opponent, you're aware of it, so that's rules 1.7, 1.9. Or it's beyond the scope of the program. They could be there with something that's totally off the wall, and you could just say, I'm sorry, this is not where you should be. Or if you decide that there's a conflict under any of the rules, which could be 1.10, the imputation to your firm, it's your call to say, sorry, can't help you. Or if they're dishonest or uncooperative. So, if somebody's dishonest or uncooperative, of course, we want you to try to rehabilitate the relationship if you can to help them. But they're going to be told up front that that you could send them away for that. Because we don't want you to have to deal with people who are not telling you the truth or who are not being cooperative. Now, at the end of the session, there's going to be 2 forms for you to fill out. And one of them is the attorney consultation form. And the law students will get all the demographic information and some of the background facts. But we want you to put down, just in a few words, the advice that you gave them. Also, in some cases, there might be an outcome. In some cases, the advice might be, you really shouldn't be filing this complaint. And the outcome might be that the client decided not to file. Interestingly enough, in family court, through our first few months there, 17% of the people that the lawyers have seen, they've ended up advising them not to file a petition, which the court is thrilled about. Us, heading those cases up. I don't expect that it's going to be like that here, but you should, feel free to be blunt with the people, to tell them, either that it's frivolous, or it might even be a bad idea for them to file for a variety of reasons. They might put themselves in a worse position to file or to take a step that they're thinking about taking in the case. The other form is going to be an attorney affirmation form, which you're just going to need to put in your information and the date and number of hours and sign it. The law students are going to be scanning that along with the other information from the client's advice and representation, and sending that over to VLP by email. And then we will follow up to get you your certificate for the CLE credit that you provided. If you're there for 2 hours, you're going to get a CLE credit. And Gail Murphy is over at the side. Gail, do we have the sign-up sheet?
We do, Bob.
That's ready to be circulated?
It is, Bob.
Okay. So Gail's going to be passing that around. And please sign up for a day or more to participate in this program so that we can at least not have to call you about the first time. And at the end, the law students, at the end of your session at the program, the law students are going to ask you if you want to sign up again. You're not required to, but we certainly hope that you will. And there's going to be a Google Calendar where they'll know exactly what dates are available and be able to get you signed up. So thanks very much.
Bob?
Yes.
I have a question. Is there a liability protection for us under VLP if we're participating?
Yes. VLP has a $1 million malpractice policy which covers all of our volunteers.
For those of you with concerns about the waiver and the forms as well, it's part of the materials that are on the website. So you can look at those, and any comments you might have, of course, we would look at if you have other suggestions. Of course, we might have 15 lawyers arguing over the language, but if you'd like to take a look at those and speak to me, or I'm sure some of our other attorneys, we'd be happy to do that.
Are we collaborating over language?
Well, perhaps. We'll see.